3:00 a.m. You're staring at the ceiling, and your naturalization certificate is sitting in a drawer like a fragile piece of paper instead of the strongest legal shield you've ever earned. You hear the headlines, raids, crackdowns, deportation flights, and your mind goes to the one place you promised yourself you'd never have to visit again: fear. Not, will they deport me? You know you're a citizen. The darker question, the question nobody wants to say out loud. Can they take it back? Can the government actually revoke your U.S. citizenship? The answer is not a simple yes or no. The answer is a legal architecture. And once you understand that architecture, you stop letting viral misinformation hijack your nervous system. This is Immigration News Desk. And today, we're going to cut through the noise with something the internet rarely provides: constitutional reality. You're going to learn what citizenship actually is in American law, what denaturalization actually means, what it can and cannot be used for in 2026, and what you can stop losing sleep over. But you also need to hear the harder truth. There are narrow, specific situations where citizenship can be challenged, and the devastating mistake is assuming those situations are someone else's problem, without ever checking whether your own history contains a silent landmine. We'll get to that because the people who get blindsided are often the people who thought their case was done. Let's start with the foundation that instantly deflates most of the fear. Your citizenship, once lawfully obtained, is not a customer account you maintain with USCIS. It is a constitutional status. That distinction is everything. The 14th Amendment doesn't say citizenship is a benefit that can be revoked for political convenience. It doesn't say the president can switch it off with a proclamation. It doesn't say DHS can pause it. It says if you are born or naturalized in the United States and subject to its jurisdiction, you are a citizen. Period. That is the legal bedrock. When you completed naturalization, passed the civics test, met the residency requirements, demonstrated good moral character, and took the oath, you didn't merely receive a certificate. You became part of the constitutional class called citizen. The legal system does not treat you as almost American or American with a footnote. Naturalized citizenship is citizenship. So why does it feel unstable right now? Because enforcement is visible, enforcement is loud, and your brain is still carrying the muscle memory of vulnerability from the years you spent waiting for approvals. That memory is powerful, and it gets reactivated when the media uses one sweeping phrase, immigration crackdown, to describe 10 different legal categories. But legally, those categories are not interchangeable. A tourist who overstayed is not the same as a green card holder. A green card holder is not the same as a naturalized citizen. A person with a final removal order is not the same as someone with lawful status. And a U.S. citizen is not in immigration status at all. That is the distinction you need to anchor yourself to. Now we talk about the word that's driving your anxiety: denaturalization. You've seen it in headlines. You've seen it in forwarded messages. You've seen it weaponized as clickbait. Mass revocations coming. They're stripping citizenship. Naturalized citizens targeted. Let's take that word out of the rumor ecosystem and put it back into the legal ecosystem where it belongs. Denaturalization is a legal process, emphasis on process, that allows the federal government to revoke citizenship in extremely limited circumstances. It is not a border officer's decision. It is not a DHS memo. It is not a new enforcement policy. It is a court-driven action that requires the government to prove that your naturalization was illegally obtained. That generally means one of two things. Either citizenship was obtained through fraud or willful misrepresentation, or it was obtained through willful concealment of a material fact, something that, if revealed, would have mattered legally to your eligibility. Notice what that requires: willfulness, materiality, proof. And in most civil denaturalization cases, the government must meet a demanding standard of evidence, often described in case law as clear, unequivocal, and convincing. Not, we suspect. Not, we don't like you. Not, we disagree with your politics. The government must prove that citizenship should never have been granted because the grant was built on a lie or concealment that mattered. And here's the first open loop you need to hold. There are two broad pathways the government can use: civil denaturalization and criminal denaturalization, and people confuse them constantly. In a minute, I'll show you how they differ, why one is rarer but more terrifying, and what triggers each one. That distinction is where the scammers make their money and where the internet spreads the most nonsense. First, civil denaturalization. This is where the government files a lawsuit in federal court to take citizenship away. You get notice. You have the right to defend yourself. You can hire counsel. There are court procedures, evidence rules, discovery, motions, hearings. This is not fast. It's not cheap. It's not something that can be done in bulk against millions of people. It is resource-intensive litigation. Second, criminal denaturalization. This is not about changing your mind about eligibility. It's typically tied to a criminal conviction, most commonly for knowingly procuring citizenship unlawfully. Think serious immigration fraud charges. If someone is convicted of certain offenses, a court can order revocation of citizenship as part of the criminal process. Again, not a mass administrative sweep, a court-driven consequence tied to a proven criminal case. Now, does that mean denaturalization is impossible? No. It means it is narrow, individualized, and legally constrained. And the biggest myth you need to delete from your mind is they can revoke it whenever they want. They can't. Not lawfully, not without court process, not without meeting evidentiary burdens. So what kinds of facts actually trigger denaturalization cases in the real world? This is where we stop soothing and start being precise. The government typically targets situations like these: a person concealed serious criminal history that would have disqualified them, a person used a false identity, a person lied about marriage fraud or immigration fraud in the pathway to residence, a person concealed involvement in persecution, war crimes, or terrorism, a person lied about continuous residence or good moral character in ways that were legally material. A person hid removals or prior immigration orders under another identity. A person obtained a green card through fraud and then built citizenship on top of that foundation. You'll notice a pattern. These are not "you posted something political." These are not "you traveled to the wrong country." These are not "you criticized the government." Free speech is not a denaturalization trigger. Peaceful protest is not a denaturalization trigger. Voting the wrong way is not a denaturalization trigger. There is no constitutional universe where citizenship revocation is a political punishment. If you hear that claim, you're being manipulated. Now let's address what's actually happening in 2026 that makes people feel shaky. It's not that the legal standard changed. It's that enforcement posture and data integration changed. You are living in a period where agencies are more willing to revisit old files, more willing to cross-reference records, and more willing to treat inconsistencies as red flags. That can increase denaturalization referrals in the small subset of cases where the government believes there was fraud. But that does not mean your citizenship is suddenly fragile. It means the government may be more active in pursuing the limited set of cases that meet the legal criteria. And even then, they still have to win in court. Here's the second open loop. The real danger for many people is not citizenship revocation itself. It's the moment you apply for a new benefit, like sponsoring relatives, renewing a passport in a complex identity situation, or filing something that forces an agency to pull your entire A file, and you discover there's an old inconsistency you forgot about. Later in this video, I'll tell you the exact category of old issues that most commonly resurfaces and what to do if you suspect you have one, because there's a smart way to approach that and a reckless way that can create more exposure than you started with. Before we get to that, I want to dismantle 3 viral claims that are poisoning immigrant communities right now. Claim number 1, mass denaturalization is coming. No. There is no legal mechanism for mass denaturalization. Civil denaturalization requires individualized federal lawsuits. Criminal denaturalization requires individualized criminal proceedings. Even if an administration wanted to be aggressive, it would still be bottlenecked by courts, evidence, staffing, and due process. The U.S. government cannot denaturalize millions of people by email. The Constitution doesn't allow it, and the courts wouldn't tolerate it. Claim number 2, they are stripping citizenship based on nationality or religion. Denaturalization must be tied to fraud or willful concealment of material facts and proven in court. Targeting people for citizenship loss based on race, national origin, or religion would be blatantly unconstitutional and would trigger immediate legal challenges. That kind of policy would collapse under equal protection principles and long-standing constitutional constraints. Claim number 3. You need to pay for special protection. This is where the exploitation begins. When fear spikes, an entire industry appears overnight. Citizenship protection packages, special registrations, emergency filings, legal shields. For the vast majority of naturalized citizens, there is no special filing that makes citizenship more secure. Citizenship does not renew. It does not require maintenance filings. It is not a subscription. Be extremely cautious of anyone selling you paperwork for a problem you don't have. Now, I'm not telling you to ignore denaturalization as a concept. I'm telling you to stop treating it as a boogeyman that applies to everyone equally. It doesn't. The question you should be asking is narrower and smarter. Is there any reason my original naturalization might be legally vulnerable? That's a real question, and answering it calmly is how you reclaim control. So let's talk about the issues that can create vulnerability, because this is where the real-world stress lives. One category is identity. If any part of your immigration history involved different names, different birth dates, inconsistent documents, or corrected information, that does not automatically mean fraud, but it can create confusion in government records. Confusion can trigger review. The key is documentation, name change orders, corrected birth certificates, consistent explanations across filings. Another category is criminal history. If you had arrests, charges, convictions, or expunged matters, the legal question is not, did you feel it was minor? The legal question is, was it material to eligibility and was it disclosed as required? Many people genuinely misunderstand what must be disclosed, especially in the early years when they relied on bad advice. If something was required and omitted, that's where risk can exist. Again, not panic, but clarity. Another category is immigration pathway integrity, particularly marriage-based residence. If your green card came through marriage and there were irregularities, separations, allegations, inconsistent addresses, or later claims by a spouse, those cases can become unstable during later review events, including naturalization. You saw this pattern in other stories. Naturalization becomes a full-file audit. If USCIS believes the underlying green card was fraudulently obtained, they can deny citizenship and, in rare cases, pursue actions that challenge the foundation. Now here comes the third open loop. Most people who are anxious about denaturalization are actually anxious about something else. Being re-exposed to scrutiny they thought they escaped. In a heightened enforcement climate, people feel like they're back in the waiting room psychologically. But the legal categories are different. Your job is to distinguish emotional residue from legal reality. We'll come back to that because it matters for your mental health and your decision-making. Now, what can the 2026 administration do to naturalize citizens? It can increase enforcement against undocumented people, visa overstays, people with final removal orders, and criminal removability categories. It can tighten border screening. It can change visa policies. It can expand detention. It can increase internal referrals. It can make naturalization harder for future applicants. But it cannot deport you because you are a citizen. You are not removable. You are not inadmissible. Those are non-citizen concepts. Denaturalization is the only path that even theoretically could lead to deportation of a naturalized citizen, because if citizenship is revoked, the person reverts to whatever status they would have had without naturalization, often lawful permanent resident, sometimes something else, and then the government could pursue removal if there's a basis. But again, that begins with proving the naturalization was unlawfully obtained. That is the gate. Without that proof, and without a court judgment, there is no deportation of a citizen. So what should you actually do right now, in February 2026, if you are a naturalized citizen lying awake at night? First, secure your documentation. Keep your naturalization certificate safe. Make physical copies. Make encrypted digital backups. Keep your U.S. passport current. This is not because your citizenship is about to be questioned. It's because in real life you need proof for travel, employment verification, family sponsorship, and replacement procedures if something is lost. Organization is peace. Second, travel as a citizen. If you have a U.S. passport, use it. That reduces friction and confusion. Dual citizenship can be real and recognized by the U.S., but other countries have their own rules. Know what your origin country requires. None of those foreign rules change your U.S. citizenship, but they can affect you practically. Third, protect your family strategically. If you have relatives who are green card holders and eligible for naturalization, this is a meaningful time to encourage them to apply. Carefully, not because citizens are under threat, but because permanent residence still has vulnerability. Certain crimes, abandonment issues, long travel absences, and yes, the reality that green card holders exist inside the immigration enforcement ecosystem. Citizenship moves you out of that ecosystem. But, and this is critical, naturalization is not a casual decision in 2026. It is a full-file review event. If a family member has any complexity, criminal history, immigration violations, questionable tax history, long absences, do not file blindly. Audit first. Consult counsel. The devastating mistake is using citizenship as an emotional shield without checking whether the application itself triggers an old problem. Fourth, if you have undocumented relatives, don't confuse your safety with their safety. You can't be deported as a citizen, but they can. Enforcement is active. Waiting for things to calm down is not a plan. Many people have options they don't realize exist. Family-based pathways, waivers, humanitarian relief, cancellation of removal, special immigrant categories depending on facts. But those options are case-specific and time-sensitive. This is where you should consult a licensed immigration attorney, not social media. Fifth, do not get scammed. If someone says they can protect your citizenship for a fee, ask them what legal filing they plan to make. There is no magic citizenship protection form. There is no registry. There is no renewal. Scammers thrive during fear spikes. Your defense is skepticism and verification. Now, when do you actually need an immigration attorney as a naturalized citizen? For most people, you don't. If you naturalized lawfully, answered truthfully, and you're not being contacted about your history, there is no maintenance action required. You do need counsel if you receive formal communication from USCIS, DOJ, or any federal agency questioning your prior applications, alleging fraud, or requesting explanations that indicate serious review. That is not the moment to DIY. That is the moment to get competent representation immediately. You also need counsel for complex family sponsorship cases where relatives have prior removal orders, unlawful presence, criminal issues, or waiver needs. Your citizenship gives you sponsorship power, but it doesn't erase inadmissibility bars for the person you're sponsoring. Now let's talk about something that doesn't appear in statutes but controls your life. Emotional residue. Many naturalized citizens carry years of immigration stress in their nervous system. You remember checking USCIS case status pages like it was a heartbeat monitor. You remember fearing mail from the government. You remember the vulnerability of being one mistake away from losing everything. That imprint doesn't dissolve the moment you take the oath. So when headlines surge, your body reacts as if you're back in the old world. That reaction doesn't mean your citizenship is weak. It means you lived through real fragility for years and your brain learned to watch for threats. You should give yourself credit for surviving that, and you should allow yourself to live in the stability you earned. Here's the reality you can hold on to in 2026 without lying to yourself. Political climate shifts quickly. Constitutional structure does not. Citizenship is anchored in the 14th Amendment and reinforced by more than a century of precedent. Denaturalization remains a narrow, court-driven process tied to fraud or willful concealment of material facts. There is no executive shortcut to mass revocation. There is no legal pathway to strip citizenship from law-abiding naturalized Americans simply because enforcement is louder. If you obtain citizenship lawfully and honestly, it is secure. That is not optimism. That is legal fact. If this video reduced your fear by replacing rumor with structure, subscribe to Immigration News Desk. Share it with one naturalized citizen who's quietly spiraling at night, because the anxiety is real even when the threat is exaggerated. And if you want us to cover a specific claim you've seen, something forwarded in group chats, something trending on TikTok, leave it in the comments. In times like this, accurate information isn't content, it's protection. You worked for citizenship, you earned it, and you deserve to sleep like someone whose legal status is not provisional anymore.